gaining new knowledge. In the same series, we have got today Radhika Dudhat to talk on the uh, landscape of succession planning in India. I'll request Professor R.S.S. Mani to welcome all. Over to you, sir.
Namaskar and good afternoon, everybody. Let me welcome you once again to our digital learning platform, which broadly constitutes the Wednesday Wisdom webinars and the Friday Fundamental series. Thank you so much, Radhika. It's a pleasure to welcome you on behalf of the Bombay Management Association and the entire family of our members, executive committee, and of course, the past presidents who are here. To cut a very strong story short, I think the importance of succession planning is just demonstrated by the fact that organizations need to plan for this, however big or small they might be. I'm delighted to share BMA's experience. We have the immediate past president of last year here with us, Chaya Sehgal, who handed over the baton to me for this year. That's Professor Mani. And I'm soon handing over the baton to Dr. Kavita Lagate in just about a couple of weeks from now. I think this is what robust organizations are made of. And this is a decision every organization has to take. But yes, organizations are made of people. And I think people don't like to take these decisions because they often end up feeling that they are not only important, but they are indispensable. I'm sure that after listening to Radhika and understanding so many aspects of individual succession planning, corporate succession planning, and both the managerial and legal angles to it, people will take up this very, very important issue more seriously. She is a veteran in this field, and I'm going to request Kavita to first introduce her to all of us, after which he has a presentation for us. Subsequently, we will take some questions at the end of the session, as we always do, with her permission. Welcome, everybody, once again. And Dr. Kavita, let's begin the session with Radhika's introduction.
Thank you. Thank you very much, sir. It's my proud privilege to introduce to you Ms. Radhika Dudhat. She is a partner with Shardul Amarchand Mangaldas and Company and has worked on wide range of transactional, regulatory and legal risk management advisory. The focus of her work over the years has been to structure transactions, provide strategy, documentation and negotiation in respect to complex, sensitive transactions and or situations across industry, including real estate, infrastructure, insolvency and bankruptcy. The legal risk management to assess and advise the management for the legal risk pertaining to the complex transactional corporate governance and regulatory issues. She has worked on very, very interesting projects like setting up of data centers in India, closure of factories, retrenchment of workmen and termination of employees, corporate governance and regulatory transactions, advisory on real estate title diligence, advisory structuring and documentation, advisory on title risk of land and respect to banking and finance, and representation on behalf of many official liquidators. Now, today we are inviting her in order to talk about the succession planning. It can be personal as well as it can be for corporate. Radhika was part of a core group committee established by Government of Maharashtra to make recommendations to the state government on legal issues relating to privatization. She is a director on boards of listed and unlisted company and is a member on the boards of industry forums. Radhika has been appointed as a chairperson of corporate law and governance subcommittee of IMC Chamber of Commerce and Industry. Radhika is a faculty and guest speaker at various educational institutions and business forums to speak on wide range of subjects, including legal, commercial, and self-development related topics. She also studies and speaks on Indian scriptures. I think this can be the next webinar for us, Radhika Madam, for BMA, where you can speak on Indian scriptures. So thank you very much for accepting our invitation, and I'll request you to start your session. And if you want, I can display the slideshow.
Yes, so I would request before you send in the slide, please go ahead and.
Is that okay?
Yes.
Radhika madam, over to you.
Request, please unmute. Fine.
So, yeah. So we'll start the presentation. Just that I don't have access to it.
I have displayed it, madam.
Yeah, no, what I mean is to change the pages. No? Acha, okay. So, in terms of setup, one second. I'm so sorry. I don't think I have access to it.
Do you want to do it yourself?
Yeah, can you just can you give me just 1 minute? Let me just see this, because my team was here actually to be able to do this. But just give me literally a minute, okay? Let me sort this out. Because normally the share screen is just 1 minute. Give me a minute. Uh, just 1 minute. One second. Can we do one thing? I'm sorry.
Radhika, you open the presentation first and then share.
No, I understand that, because I am so sorry for this for the whole team. The thing is, I was given to understand the presentation will be shared directly from the. Just give me 1 second, okay? I'll just do this. 1 moment. You need one. You just presentation from your end. I'll take it page by page, because I don't want to right now.
So this is your first slide.
Yeah. Just give me 1 second. I just. Okay, let's just start. So in just 1 moment. Huh? Why am I doing this is because I had my colleagues who were sharing this. So there's a little bit of a. I need to just make one phone call.
Radhika, it seems you have a bandwidth problem. You can switch off your video.
So let's just take it page by page. We'll do it by page right now. So we are going on page number 4 right now, which is on succession planning. Yeah, page number 4, please. Yeah. So, yeah. So, dear friends, I'm sorry about this glitch because I was under the impression that the presentation is going to be, taken. The charge of the presentation is going to be taken over by the sessions itself. So, let me take you through the presentation. So, succession planning as an overview is essentially an aspect of estate management. Typically speaking, when we are looking at succession planning, we look at it at different aspects. Here in this presentation, we are doing the landscape and the overview of 3 main areas, which is for corporate, for promoters, and for individuals. As far as corporate is concerned, today succession planning has become not only something which is, preferred, but in fact required, because in the legal framework which is in existence today, corporate governance as well as planning, the succession of the key managerial persons becomes an essential to be able to have business continuity of the organizations. Also, further, for promoter-driven companies, this becomes very important, especially because to be able to have the next line in chain. So, in this particular presentation, what we have done is we are giving you an overview in regarding to the legal framework that is applicable as regards to the companies, to the promoters, and the individuals. Just go on the next slide. So, when we are looking at the next slide, when we are looking at corporate succession planning, as far as corporate succession planning is concerned, today the Companies Act, as well as the SEBI listing obligation and disclosure requirements, necessarily require that the companies have a very sound manifesto that is prepared, where the succession plan in respect to the management, as well as the KMPs, as the key managerial persons, is actually made available. This particular framework essentially needs to be into place, keeping in mind, of course, the requirements of the organization, and also to be able to make sure that the people are actually trained and brought up in line of succession over a period of time. Just to be able to share some of my own experience in this regard, and in terms of how this becomes important. As you know that today companies are complex organisms which not only are responsible in terms of their businesses, their finances, marketing, and so on and so forth, but also in regard to the know-how and the information that they have, as well as the goodwill they have in the market. Today, in fact, if we look at the companies, a large amount of the decision making that happens within the company is really determined by both the management of the company as well as the independent director sitting in the company. The price of the shares of the company is also determined by the market perception of how good the company is run in terms of the corporate governance, as well as how well the company has the framework connected with their own succession planning. And hence it becomes extremely important, looking at the sensitivity of the situation, that the corporate succession plan is typically done. Now, the way the corporate succession planning typically gets done is by 2 methodologies. One is, of course, to be able to do lateral hire, whereby you take on people laterally and to be able to, at the quickest possible time, bring them up to speed for the organizations. Naturally, these are people which have a huge amount of the domain expertise and industry knowledge. The second methodology is, of course, to be able to home grow and to be able to nurture the individuals within the organizations. Both of these are something which the companies do experiment with. But essentially, there are proper manifesto and documentations which are there, which lead in terms of how and when the succession and the planning would happen. Let us go to the next slide. In case of the, one of the very important reasons why corporate succession planning is also important is because of the fact that, there are situations where it's not only about one single individual or two individuals that may need to be quickly replaced within the organizations. Unfortunately, there have been situations where on account of maybe natural calamities or some kind of severe situations like terrorist attacks and others, where a large amount of the management, if you recall, unfortunately, during the 9/11 as well, a large amount of the management in respect to organizations were seriously debilitated. Hence, unless and until the organizations put together a very concrete plan relating to succession planning, it becomes a very serious issue for the corporates. And that is the reason why it is always encouraged in case of large companies that there is not only an immediate succession plan, but also a lateral succession plan, which is a backup to the first in respect to almost all positions. Also, as a part of the corporate succession planning, one of the most important criterias is in regarding to not only individuals which have information and experience, but also in regarding to the repositories of the documents and the data that gets created, so that there is the information that is available for the successors of the organizations to time to come. So one of the, as lawyers as well, we always recommend our clients to be able to create very detailed repositories in terms of information flow, both in terms of regulatory, and contractual, and of course litigation. These are very important to ensure there is continuity in terms of knowledge, as well as in terms of the strategies which have been nurtured over a period of time get actually implemented properly. We'll go to the next slide. The next one, please. Yeah. The situation becomes a lot different when it is the promoter-driven company. Typically speaking, as we all know today, that although they are promoter-driven companies, these companies also, on account of the fact that on listing require to comply with all the laws and the legal framework that is required for corporate governance, and have within on their boards even the independent directors which sit, it becomes imperative to be able to ensure that the proper succession planning is taken place. In fact, so much so that the investor community, which is constantly monitoring the companies in terms of its performance, both financial as well as commercial, as well as in terms of its corporate governance and norms, give a considerable value to succession planning, since they realize that the value and the unlocking of the value in the company truly resides in the basis of the continuity of its business. And hence, in case of promoters, we always see issues which are rather complex sometimes on account of few factors which all of us are aware of, and I'd just like to take you through those. The first and foremost thing in regarding to promoters and in regarding to succession planning that we need to keep in mind is that as far as the promoter is concerned, you could always have a family of group of individuals, a family over a period of years has been controlling a particular company, or a particular promoter which is the first generation promoter controlling the company. In both cases, the biggest issue in these areas, it becomes in terms of the control that is exercised in the company. And since the shareholding typically is fragmented and scattered, it becomes imperative that it becomes imperative that the succession planning is essentially planned in a manner where the control and the exercise of control in the companies is vested properly. If you look at large companies and even banks such as Axis Banks or Asian Paints, Bharti Airtel or Bajaj Auto, or even the Kirloskar Group or Cipla, some of the characteristics of these companies is the fact that they have created a proper, robust succession plan. One of the very important factors that go on to carry and create a robust succession plans, especially in promoter-driven company, is when they have arrangements which are normally tied up by way of either family trusts or by of family arrangements, which put together the terms and conditions in terms of how everybody would really be voting on issues, how a decision making in respect to intellectual property, decision making in terms of growth and expansion, as well as investments into the company will be made. So one of the most important things that we as a law firm always recommend to the promoters, and especially which are promoter driven companies, where it is a large group of promoters which are holding on to the company, is to be able to have that legal structure in place. That legal structure is typically a contractual structure or could be by way of a trust. One other issue that typically that gets covered vis-a-vis these companies, which are family-run companies originally at least, is in regarding to the intellectual property. So the intellectual property in terms of the essential trademarks, the logos, including as in the case of the Tata group of companies, is essentially held and vested in the parent company, which or a holding company which essentially holds the intellectual property of the company. And over a period of time, that company then licenses the IP which is required and relevant to the group companies, subsidiaries and others. And also there are terms and conditions that are governed under the license agreement that essentially govern the manner in which these companies are run and PR in this company is run. So the key points to remember as far as the corporates are concerned and as far as the promoters are concerned are essentially the first and foremost being the putting together a clear succession plan in regarding to the management as well as in regarding to the KMPs. The second issue, the second point in this regard is in regard to the information flow. So the confidential information, the key information could be the trade secrets of the company, the key contracts of the company, important key financial aspects of the company or the strategy of the company is always held and is also created a database whereby this information is stored carefully for the future management of the companies. So we'll just go to the next slide now. Yeah. When we look at the individual succession planning of the company, individual succession planning really, for individual succession planning, it's rather a complex process. And the complexity really comes is on account of three factors. First of all, in terms of individuals, either you can have a framework which is created by way of proper wills that get created, where the framework in terms of how the transmission of the assets and the inheritance will really move from one generation to the another is set out. In some cases, it is intestate, where there is no will that is provided, as a result of which very clearly it is something which then the individual laws applicable to an individual in terms of their own personal laws will become applicable. The other aspect of it is in some cases, individuals also, because of the amount of, to the extent of they want to protect the generations to come, not just the immediate one, but the further ones also. They also create structures such as trust and others. So when we're looking at individuals, the first and foremost thing to understand is either the individual creates his or her own will, through which the framework in terms of inheritance and others is set out, or secondly, the individual creates a structure like a personal trust, wherein the assets entirely move into the trust, and then the trust essentially administers the entire wealth for the generations to come. And the third, of course, being where there is no document or an instrument or a structure which is in place, in which case it is an intestate. We'll just go to the next slide. One of the important things that we should keep in mind in regarding to individuals, because a lot of transactions that get done with individuals is on account of even power of attorneys, which are executed by individuals to other family members. Now, power of attorneys, although empower every person to act to the extent of the power which has been given, and power of attorneys essentially are either general or specific power of attorneys, only in the case where the power of attorney is accompanied by consideration do these power of attorneys also survive the death of the person. Otherwise, typically speaking, the power of attorney comes to an end when the person passes on. So essentially, when you're looking at succession planning, uh, the the three aspect of it which I mentioned, one was the will, the second one was very clearly the trust, and the third was in case you die intestate. We will right now uh, talk a little bit about the private trusts and the formation of private trusts. Private trusts are essentially a very important mechanism which has been come forth, especially because where individuals which have very large amount of wealth, or individuals which we want their wealth to be used and utilized as well as transmitted from one generation to another without that wealth being broken up. A lot of time there are family old ancestral properties. A lot of time there are interests whereby you want to even carry on certain private endowment work in terms of charity and others, or there may be other serious situations. For example, there may be children who may be handicapped in certain manner, or maybe requiring special needs or requirements, as a result of which these trusts become extremely important for succession planning. So typically speaking, in a trust which is governed by the Indian Trust Act, uh, there is a settler. Settler is the person who's actually settling the entire amount in favor of the trust, which is run by the trustees for the benefit of the beneficiary. Clearly, the trust has its own objective, which is clearly set out, the number of trustees and the obligations. So the framework of the trust gets set out. One of the other advantages of the trust is because the trust itself becomes a legal entity, and where taxes are paid by the trust and the legal obligations are fulfilled by the trust. There are a lot of other benefits that accrue in terms of having a distinct life of this particular trust, and especially when certain endowments and certain trusts are created for the benefit of certain assets. They really go on to protect the assets, as well as ensure that the capital is not eroded so easily, and which is looked after by these trustees. Of course, needless to say, one has to take care that the trustees themselves and the appointment of the future trustees again is a process which is taken with a great amount of responsibility and seriousness. In fact, there are a lot of family offices today which assist people in creation of these trusts, as well as how to really work this through. We'll just do the next slide, please. Yeah. So, in regarding to the wills and the trust, one of the most important thing that we need to keep in mind is everything that we can do in regarding to transmission of any kind of an asset, property, whether be it movable, immovable, and also tangible, can only be done if it is self-acquired. So only to the extent that it is self-acquired or actually vesting in me. So for example, whenever I have because of my self-acquired income, I have bought many immobile properties. I have bought a lot of stocks. I have liquid cash, as well as other maybe jewelry and many, many other things. All of this together, I have the right to be able to decide who I want to give it to. And that is not a problem at all. As far as the trust is concerned, I can also make sure that all these assets move into the trust for the trust to manage. One of the very important criteria that is to be kept in mind in regarding to trust especially is there is a stamp duty implication when we move the asset from the settler into the trust. So this is something that is very important that is to be kept in mind when we look at these issues. And especially they need to be looked at in detail and advised by lawyers and chartered accountants for this purposes. When we look at the wills, there are properties which are either self-acquired, or there are properties which are which may be ancestral and the rights that may be flowing on that regard. Now, it is not as if that the ancestral property cannot come within the will. The only difference is the ancestral property can come only to the extent of the share that vests in me. So I certainly can bequeath my share in an ancestral property to whoever I want to, but certainly it cannot be to the exclusion of the legal, the rightful legal heirs. That is very clear. So the most important part about any kind of an asset that we need to keep in mind is wherever the ownership is very clear and vesting in you, that is something. And if it is income which is earned by self-earned acquired property, there is no problem at all. In regarding to assets which may be leases, which may be long-term or short-term leases, it will have to also be governed by the lease document or the instrument that actually decides it. And that is extremely important in certain cases, or if there is any specific statute in that regard. The last point is in regarding to tenancy rights. Tenancy rights also in case of an immovable property are a complex issue, as we know, and they are governed by tenancy laws. And tenancy laws are also laws which have been which are in existence since quite some time, and they have a very specific way in which those rights are created and also can be passed on from one generation to another. So this is something that is very important, and especially in regarding to tenancy, it is very important to reach out to a lawyer and understand what can be or can't be done, because it's extremely technical. For example, when you're living with a person who passes on and who was a tenant, establishing your right as a tenant becomes extremely natural and in course of time. However, if you were a person who were not living at the time of death, and that requires a certain mechanism, a process which needs to be initiated beforehand in terms of to be able to get that benefit to come to the legal heirs. So essentially, when legal heirs look at um, um, any transmitted property that comes by way of inheritance, there are many issues that one looks at, primarily in terms of two things. One, if it is a property which is self-owned, then it's much simpler. If it is an ancestral property, then the personal laws come into play, and then of course that property has to be divided in the manner as permissible under those personal laws. So we'll just go to the next slide. So if you look at a comparison between a testament and an intestate proceeding. Testament is a proceeding where you have wills, and on account of will, the will very clearly sets out who the testator is, who the beneficiaries are, what are the assets, who gets what. All of that comes out very clearly. Typically speaking, the will in itself is today, the will, when being executed, there are certain criteria which are required simply because the will should not be challenged in future. And some of the requirements for wills essentially are that the person is in a mental capacity, in a good physical condition of knowing what is being done. There is a certificate of the doctor which really clearly says the person is in a proper mental sound condition and was in a condition to be able to make the will and execute the will. There are two witnesses who witness the will as well. The will also sets out very clearly, who is it that is going to implement the will. And that is very important. I mean, it's not necessary, but it's always generally set out as to who will actually implement the will, and that is necessary. Typically speaking, especially where there are large amount of immovable properties that are involved, or large amount of estate which is being part, which is being apportioned amongst various people. Typically, we always advise that such wills should be registered. Though it is not compulsory to register, it's always advisable to register those wills. Once the will is registered, and on passing of an individual, typically speaking, the will can either act as an instrument itself for effecting the transfers, but most often than not, most agencies, whether they are banks, demat accounts, or various others, will request for a probate, in which case that probate will have to be applied to the court, and over a period of time, there is a process by which the court actually comes out with a clear order setting out the terms and conditions of the will. The one other instrument that we need to keep in mind when you're looking at wills is an instrument called codicil. Codicil is an instrument where, if in case the person who is the author of the will does not want to change the will again and again, you can make a subsequent instrument called codicil, which either amends the will to a certain extent, specifically to a certain extent, or adds a certain provision which is added into the will. So both these instruments are read together, and of course the codicil will very clearly say which instruments, which provisions continue and which are replaced, or which are there. So this is something which is very important to keep in mind, that the will is an instrument which has to be extremely clear. The will is an instrument which requires very detailed information in respect to assets, which are set out very clearly according to the asset class, which is mobile or immobile, as well as giving description and details in that regard. It also talks about, in the manner in which the assets need to be shared between parties. So sometimes the asset, of course, goes entirely and directly to an individual, and sometimes it is required for it to be shared. When the asset is really shared with a particular individual, then it is very important that the percentages of sharing are also set out very clearly. The other very important thing to remember in general is, in terms of all the assets, instruments, bank accounts, demat accounts, the nomination is extremely important. Now, what is important to understand is, nomination is not really the evidence of title in itself, because you can nominate people as far as your flats are concerned, as far as demat accounts are concerned, as far as your bank accounts are concerned, but either the ownership or the inheritance of those will be governed either through a will, or by essentially through if the will is not there, then it will be done according to the succession law that is applicable, which could be the personal law of a particular person. Now, what happens when a person dies without a will? In which case, under the Indian Succession Act also, that you would have the personal laws of the deceased, or the Indian Succession as may be applicable, which will essentially apply to you. And in each of the laws, whether it is the Hindu Succession Act, or under the Muslim, or under the Parsi, each of these succession acts very clearly sets out the process in which the personal laws will apply, and how it would really go. So one of the important things that we need to remember is that whenever somebody dies intestate, typically speaking, a succession certificate is prescribed and required by most of the banks and others, simply to denote who the successor is. Now, the succession certificate is taken to be able to look at that who the succession is, and is generally used as far as all the movable properties are concerned, like depositories, fixed deposit, bank accounts, and others. And letters of administration are something which are taken up where you want a specific right in respect to an immobile property that we are looking at. where letters of administration are taken to show the legal heirs in respect to a particular property. This becomes extremely important. We'll take on to the new slide, please. Just one more. So when you look at the legal framework that is necessary for the succession planning in India, all of these acts are essentially that are, they come into the forefront. And when you look at the first few acts which are there, right from the Indian Succession Act, Hindu Succession Act, the Waqf Act, the Special Marriage Act, the Hindu Marriage Act, and as far as these are concerned, these are all coming under the personal laws that are there applicable to individuals. The ones that come thereafter, which are the Companies Act and the LODR for SEBI, is something that is there and applicable to the companies. The Limitation Act is an important act that comes into play where there is a challenge that requires to be made in respect to any of the bequeath that is done. Of course, in case of challenge that is done, and if you can show reasonable causes, the courts may be lenient to allow a particular matter to be filed even after the limitation time is over. But that is something that needs to be shown and done. The last point here is in relating to individual states, because states also have specific requirements in respect to where the probate sometimes becomes compulsory, where of course it's not required or it's not said. So when you're looking at the framework of laws, as you can see, the complexities of laws are not only in terms of the framework, in terms of what becomes applicable. The complexity of the laws really comes into fact in regarding to what is being bequeathed or what is being in the succession plan that is coming about. Also, we need to keep in mind that when we are looking at succession, the more there is clarity in terms of the framework, the better it is. Because what happens is, anything that is not clear or ambiguous is in fact the breeding ground for people to be able to then file contentious litigations. And as we all know, litigations unfortunately in our country are so long and protracted that the whole point typically of having a instrument that is there for transmission becomes completely moot. Hence, it is extremely important that the assets typically are set out clearly, the beneficiaries are set out clearly, the shares of the beneficiaries are set out clearly, and as far as possible, legal entanglement is reduced by ensuring that the asset classification to the heirs is done in the most elegant manner. When I say elegant, means where there is going to be lesser and lesser contentious issues. We'll go to the next slide. There is one important concept that has come into play recently, and it is called the living will, which is something that we need to keep in mind, where the Supreme Court has held that a person who's an adult and of sound mind can actually make a living will, whereby you can actually direct very clearly a person who is given a power to make decisions on behalf of them, especially if you're incapacitated. So, a lot of time what happens is, if you want that in the event of any unfortunate eventuality of incapacitation, you want to be looked after by somebody in specific in person, where you want to maybe keep certain amount of ready for it, and all of that has to be specified in this document. Because unfortunately what happens is, if you need to be looked after by your children or your wife or your husband, then there is no problem, or an immediate kith and kin. It becomes an issue when you want somebody else who doesn't have the legal right to look after you. Then in which case the living will becomes extremely important. The living will also enables people to be able to give guidance. For example, in case of certain incapacitation, as well as in case of when there is any kind of accident or any issue of that sort. If you do not want to be where your life to be prolonged for a very long time. Because what happened was, in certain matters, the cases came where people were in a state of coma and vegetative states for the very long period of time, and nothing was being done. And as a result, where it was very clearly written in a will that in case of incapacitation, and where there are clear instructions to say that, when you know for a fact that there is no other possibility, then please do not prolong life with extra intervention. This, of course, is a legal process. So when this gets done, it has to be done in a specific manner. It has to be taken before a magistrate's court where it gets properly executed, witnessed, and all of that, to ensure that people do not misuse this particular power. But this is something that is very important, and wherever, especially where one's near and dear ones are very far away and maybe out of the country or others, then this becomes a very useful instrument for people. We will go to the next slide, please. So in conclusion, when you look at whether it's a company, whether it's a trust, or whether it's an individual, the most important part about any succession planning always is in regard to one, in case of individuals who make either wills or are intestate or have trusts, in terms of, very clearly having an clear idea about what the assets are. They have to be very clearly set out, both in terms of movable and immovable and intangible, if any, as well as how it is going to pass on. One of the very one important and interesting things that we need to keep in mind is, a lot of times it becomes very important to give even instructions. Like, for example, if there was a spouse which was there and there were children, where one may say that, you may give the enjoyment of the property to one person, like, for example, the spouse. For life, you can enjoy the property, but the property can be just enjoyed and not sold, and then maybe enjoyed by the children subsequently. So this is something which is what we need to look at and understand from time to time. Uh, it is something that has to be clearly set out in the documentation that we have. So wills are an instrument which enable people to very clearly give a good background in terms of seeing how the person who was really bequeathing the property wishes it to be transmitted. So what I'd request now, if it's okay with everybody, that if we can do the question answers right now, it would be ideal.
All right. Thank you so much. That was.
And I first of all apologize, because I'm in a place where I didn't have the presentation, and it was going to be either shared by my colleagues, which were going to have the access to it. So I asked, I'm terribly sorry for putting everybody through the inconvenience.
Don't worry. I think we have all learned what one of our colleagues said, digital patience. We know that these things keep happening time and again, and this is least of our concerns. It has been a very, very detailed presentation, and a lot of what you shared went into the finer points and also indicated the depth of your experience. Thank you so much. It was wonderful listening to you for all of us who are here this evening. I'm seeing a couple of questions in the chat box, and we will begin to take them. Chaya, can I request you to start? You had a question. It will be good if you can pose it across to Radhika. Please go ahead.
Thank you, Professor. Hi, Radhika. I was asking you to explain the finer implications of living will with the help of some tricky illustrations you might have encountered professionally. Because that euthanasia continues to be a huge debate everywhere.
Right. And so in our country, even as far as the Supreme Court is concerned, they're very clear about it that, euthanasia is not exactly, is far away from the cards right now. So the only one aspect of it which the Supreme Courts have considered is when the person is totally incapacitated, where literally the faculties really are not functioning and you're in a vegetative state. And yes, at that time, because of this specific living will and the prognosis of the doctors, which is very clearly set out by independent doctors, which is taken, then it is implemented. Because only then pulling the plug, so to speak, is not an easy thing by law in the country. It requires a great amount of scrutiny, which requires one, instructions from the person itself. Second, it requires validly given instructions from the person itself in form of a living will. It requires examination by doctors and their ways to say that really nothing can be done and there is no other means. Only then is it possible to pull the plug.
And in continuation, if I may ask you one more clarification, that I have heard, of the talks of it being possible in Switzerland, and then people have been saying that, okay, then how about taking the patient to the Switzerland? Because if the life of a patient is a living hell because he or she is forced to live, then how about carrying the person to Switzerland where it is allowed? So those kind of things are also allowed within our own constitution, or they're just the flights of fancy, or just the thought because we see somebody suffering and we feel it's unbearable?
Yeah, no, unfortunately, under law, you're not allowed to, go specifically and have euthanasia available. The reason is because, it is very difficult to really go into that particular jurisdiction to know really what happened, because it's one person's word against the other to say that how this really happened. So hence, as far as our Indian law is concerned, there is a very specific method in which death in a foreign land is taken on record in India. And there is a process given. Unfortunately, I don't have it here, but there is a very specific process given where there is a death certificate which is provided. It has to be authenticated. There is the Indian embassy in that jurisdiction that gets involved, and only then that happens. So euthanasia as such, while I understand that it is extremely important in certain cases which are very, very difficult and unbearable, but it is in India, it's not available.
Thank you.
Thank you.
All right, I'll move on to the next question. Is someone's asking you to share your experience. Are succession planning issues? 1 minute. Are succession planning issues more common in small and medium enterprises where one does not have rigid systems already in place? Could you throw some light based on your experiences?
Yeah. So in fact, succession planning issues are, so there are two parts to it. Wherever there is a board-run company, there is the process and form in that regard is, generally speaking, the frame is already there. Because as a part of governance today, in fact, a succession planning becomes extremely important as far as the KMPs are concerned. And all the more reason for companies to really take it up and work on it. The other reason why also it is very important, and the companies know that one needs to really work towards it. I'll come to the question in a minute, but this is important, so I'll just say, is the fact that it takes very long time to get people up to speed. Because the information in regard, especially at that level, when you're taking key positions like finance, marketing, maybe even legal of HR of a company, it is very important to be able to have people with a know-how which is completely available to them. In case of smaller companies, of course, it becomes harder because two reasons. One, the companies may not be open to bringing professional from outside. If it is a family-run company especially, they may not be open to bringing outsiders to run their own company because they may not find merits in really having professionals from outside. In certain cases where they do find merit in it, then of course they look to it. But typically speaking, I think it requires a lot of planning, whether it's a small company, a medium company, or a large company, because one would necessarily require to identify people, train them accordingly, or at least put processes in place so that if the person comes from as a lateral hire also, they are able to come up to speed.
All right. I appreciate what you're saying. Professor Moradian, you had a question. Please go ahead, sir.
Hi, Radhika. Good evening.
Good evening.
The question, I have two questions. One of them I'll speak, if Professor Mani allows later on, we'll take up. Question is, it's a listed company, let's say. The
Yes.
majority shares of the company, in spite of it being listed, 50% plus are owned by the promoters, the promoter family. And the promoter family is who's the chairman, plus there are 3 offsprings, and the shares have been distributed as well as distributed among several trusts.
Correct.
Can the board of directors pass a resolution as to who the next chairman will be and who the next vice chairman will be? And it will be sound in terms of laws of the land. Can we pass a resolution?
So, so the thing is, first and foremost, there are categories of resolutions that are there in terms of what resolutions can be passed by the board and what are the resolutions that are there which require the shareholders' approvals, right? In case of resolutions such as this, since there is a promoter which is holding the majority shares of the company, and very clearly the control and the management of the company vests with them, the directors, and I would presume in this case they would be primarily independent directors who would be there, who would be looking at it. The recommendations of those particular directors which will be there, which will have to be deliberated amongst the board members. It will have to first of all be brought as a resolution to the board. Second thing is that then it will have to be voted on as far as that is concerned. But the fact of the matter is, if the promoters themselves are not in favor of it, there is a possibility that this will get litigated, because there is no other way, because a lot of times I understand completely what you're saying, because the succession of the company, especially in a listed company, can sometimes be, if the independent directors feel that there needs to be an overseeing of a third party professional individual as a chairman, which is necessary in the interest of the company. Um, and if the promoters still do not agree to it, I think this is a matter that will get litigated, unfortunately, because it will have to be passed with a majority, and then the numbers will have to see. But if we are saying that the promoters number of shares, a number of people will be far exceeded by the other votes, then although it will be validly voted, it will be litigated, um,
What?
essentially.
Just an interruption here. What if the next chairman and vice chairman will be from amongst the family? That resolution is brought to the board. And of course, passed by the AGM later on by the other shareholders.
Yeah, but you mean to say you identify a specific chairman, right?
Yeah, a particular chairman would like to say that we want a resolution passed by the board requesting that the next chairman and the vice chairman will be these 2 family members only.
Yeah. So
Not the
so
family owns the majority shares.
correct. So I think as the promoters of the company, one can always give an indication to saying that this is what we like, because these people are the ones who we have been training, or getting them ready to really take on the reins of the company, so to speak. However, the fact of the matter is, in the given scenario, and scenario that is unfolding world over, where essentially competence really matters, capability matters, these are issues that are going to come more and more and more. where, you know, there could be a possibility very much where the board of directors may actually oust the person, who actually founded the company. If you recall, even in case of Apple, where Steve Jobs had to, you know, he was taken out of the company and the company was run by the board. So it is a tricky situation, but you're right. They can certainly indicate, but ultimately it will be the board's decision and the voting will have to determine it.
Thank you. Thank you,
So,
Radhika.
yeah.
All right, Indrapalji, you had a question. I hand over to you now. Please go ahead, sir.
No, I think my question was that what are the kind of preparatory steps that companies can take, particularly the family-owned companies, to prepare the successor of the current chairman or managing director? I mean, what could be that process? What should be that ideal process? Should it be a family member or should it be somebody from outside? We know the famous Ranbaxy case when there was an outsider which ran into difficulty later on.
Yes.
And then the family members took over and the company was ruined completely. So what could be a better way forward apart from I'm talking purely from the management point of view.
Correct. So I think this is
I think we've lost your audio. We are not yet able to hear you. Well, I guess she has got disconnected. We'll just give her 2-3 minutes to join back. Please stay on with us in the meantime till she gets back her connection. We can hear you, but there is a break in your voice.
I think the connection is lost.
That's right. Kavita, will you like to use the time to just give more details about our Wednesday program to all our participants, the next Wednesday program?
Yes. Last time when we started with Wednesday webinars, that time also we had one session on migratory labors, and after one full year again, able to see the screen?
No, not yet. Now we can.
Yeah. So we have another in the series, COVID and impact on migratory labor in conversation with Dr. Rajan Mehrotra and Professor VP Raja on April 28th from 4 o'clock. So all are invited for this Wednesday webinar, and I'm sure the discussion between a person who has worked in ILO and a professor who is in very strong in economics and having a background of being a secretary of government of Maharashtra, I think that will be very interesting conversation. So I invite all of you to be the witness to this conversation between Dr. Rajan Mehrotra and Professor VP Raja.
Great. So this is the forthcoming Wednesday from 4 to 5:30. Unfortunately, Radhika has still not been able to join us, so we will just hope that she can come
Radhika,
back.
are you there? I can see her, but name is there in the participant. Radhika? No, it is still breaking. Your voice is still breaking.
Can you hear me? Hello. Can you hear me?
Yes, little better, but not clearly enough.
Sorry about that. Terribly sorry about that. I didn't know what to do.
Radhika, if you can put on your video.
At this moment, she is not in the call.
Mm-hmm. We offer vote of thanks because it's a really difficult, I think, at our end.
I think you can wrap up and we can conclude the session.
Yes. So it was very interesting to know the landscape from how the corporate succession planning and the individual succession planning and legal angle. I had a question to ask, but the time and the opportunity I did not get. We generally make nominations. We do in the banks nomination and things like that. How legal it is, and will that suffice in place of a will? That was my question. But some other time, I think we can request Radhika to answer. And this full legal battle, I was trying to relate it to the Hindi movies where power of attorney and the board deciding something else. And it has been those very dry subject of law, but it has made the Hindi Bollywood movies very interesting plots for the making of movies. So Radhika, thank you so much. Now you are there. So if we can continue for 5 minutes or so.
Sure.
I
Can
had
you hear
a
me?
question that many a times we do nominations in, say, bank accounts or some other cases. Also, nomination is required and compulsory, and we do that. How legal it is, and is it a replacement of a will?
No. So nominations are essentially an administrative power that is given to the person who is a nominee. It can so happen that the person who is nominated is also the beneficiary in the will. But given the current, jurisprudence and the case law on this subject generally, nomination is considered to be only a representative who can be a custodian to do the necessary administrative work in regard to a particular asset. Whether it is, say, cooperative societies whether it is, for example, as far as the bank accounts and others are concerned. So it is very important, because the banks found that sometimes there were a lot of challenges in court cases which are filed by other heirs who were not nominees in that particular account. So to be a joint account holder is extremely different, because that's your legal right, and it comes to vest in you. However, in case of a nomination, although it's a benefit to have a nomination, today you will see, even if a nomination is there, they will ask you for either succession certificate, or they will ask you for a will or a probate or something of that sort. So to avoid any kind of a confusion, although nomination is there, either you make them joint account holders, which make it very simple and straightforward, in which case any one person even passes on, the other person automatically takes on. Otherwise, nomination can be a contentious issue.
Okay, thank you. Any other question? Yes, sir. Moradian, sir.
Please unmute.
This is a little dicey question. You may pass it. How do you look upon this case of Ratan Tata and the succession planning, which all went hunky-dory, absolutely topsy-turvy? What's your take on that? Where did they falter?
So our firm represents the Tata in this particular matter. So our position as far as this is concerned, obviously, is out there, and the Supreme Court has given a verdict as far as that is concerned. No, let us not. Okay, let me do this. As you rightly said, it is a tricky question. So let me just look at it in a different manner. The issue is this, that one aspect is, and we are not talking about the Tata mystery issue at all right now. I'm just talking about generic issue. If you look at the generic issue, there are 2-point issues here. One is, of course, in terms of bringing on a new successor, and this can happen to any company. You see, you can bring on a successor, and the successor may not, and maybe the successor is also doing things which are fine, but it may not be according to the ethos which is established, which the family that is running it, the family which is really has the control, essentially, has it. There are 2 aspects to it. One is there always needs to be a protection when succession, about corporate succession planning. It can be put together in a contractual framework. Okay, that is the first and foremost important part of it. If you're in an executive capacity and you come into the company, then you're governed by the contract under which you were brought in. So that is a very important point that we need to always remember and keep in mind. Merely by board resolutions, and people were just bought in. But today you will see there is more and more trend in terms of even a contract which governs the role and responsibility. My only limited point here that I'd like to make, which has been made right now, is that when you're once on a board, there is a process under law where how you can take out a sitting director in a board, right? So it is not possible to simply just decide and say that I am it's not somebody that I get along with, and so I will remove. Law requires you to justify very specific grounds to show that the behavior and the conduct of the person was ultra vires to either the articles of the company or the memorandum of the company, or was not in the interest of the company itself, and hence such a person can be voted out. Hence, the limited point being, one, there should be a contractual framework which sets out very clearly the roles and responsibility. Number 2, the necessary statutory provisions will need to be followed in terms of the manner in which somebody is removed from a position. Because whether we like it or not, that person also under law will always have a record that will continue for the longest time, right? Because once you're removed for a particular reason, that always remains on a person's record as well.
Thank you, Radhika.
Thanks. Any?
I think these are the questions, and I will request everyone to please switch on your videos. We can have a quick photograph for our record. And thank you, Radhika, for such a interesting topic that, and you have covered a wide range from corporate succession to individual succession. And before you were out in the meeting, I was talking about the dry subject of law, which is which got attracted very much by the Bollywood filmmakers, because
Yes.
the dilemmas of these legal twists and turns we always see in movies, may it be power of attorney or the board voting out someone or things like that. So it was very nice to hear you about the succession planning and a wide range of succession planning you had talked. It's my privilege to thank you for coming to BMA Forum for this Friday Fundamentals and talked about a very fundamental topic which is very, very close to every one of us, and becoming very important because nowadays the family fabric and the societal fabric has become very, very different. I thank all the participants.
Madam, I had a question. I put it to Professor RSS Mani.
Okay, I just got it now. Yeah.
Yeah.
Can I read that to you, Radhika?
Yeah, please.
Okay. It says that's Mr. Sinha. He is the co-founder of a company nurturing a professional to take charge by 2023. What care should he take so that the next management follows the core principles and values, or my children may take control if the person appointed as a professional misuses the power?
Yeah.
So
Can I elaborate a little bit? Radhika, I'm a co-founder of the company, and I have been managing the company for last 8 years. Next 2 years, I will take the retirement. I have my children, but like JK Paper Mill, my vision is not my children, but apt professional should manage it. So we have identified, I have nurturing her for last 1 year. But one of the confusion I have, like Mr. Bowman was telling, we have to ensure that the next person follow the principle and core values of the company. And if that person is not following, what check and balances should I put so that I or my children can take back the charge and take the baton to next person?
So the first and foremost thing that is required to be done is the appointment has to happen, as I mentioned, at an executive level within the company. That executive level has to be put together in a contractual framework. The contract should be for a definite tenure, which should be renewed after a certain time. So for example, if there is a contract which is for every 3 years or 5 years, right? So for every 3 or 5 years, it can be renewed beyond a time. Typically speaking, such contracts also have two very important provisions. One is, of course, where you can terminate the services of somebody for a breach of contract, where the terms and conditions are set out and you don't adhere to it, and so there is a breach of contract. The second aspect of it is for no fault termination, which means you have not committed any fault, yet I want to terminate the services. In which case, typically what happens is the person is given salary in lieu of a certain period. And naturally, because people are coming, leaving certain other jobs and other things, people always decide that if you need to terminate me for no reason at all, then X amount will be paid to me when I'm terminating. Then there are provisions like the gardening leave, where you, if in case it's sensitive and confidential information, then even beyond the period of your own employment, you have a gardening leave where you actually continue to not take on other work, but you can't restrict them for too long. So remember that, because it is anti-competitive practice. So that's not possible to restrict somebody which is a restrictive practice for employment. So primarily, the way I would look at it is better to set out a manifesto of clear principles. Your articles and memorandums should also reflect it so that it's not something out of the view. And then, of course, there has to be a contract in place, and it has to be for a definite tenure, which only gets renewed depending on performance.
Radhika, can I add one more thing to that?
Sure,
I'm
please.
Shankar. Yeah, you see, this contract is not only applicable when he signs the contract, but even when an offer of appointment is made, even then it is enforceable. Supposing you want to withdraw the offer,
Yes.
thinking that there could be some problems, you are still liable to pay him compensation.
Correct. So because they may have left the other service also, in lieu of the fact that you have offered them service. So all of those terms and conditions have to be properly reviewed, and only then those offers have to be made.
Thank
But
you.
thanks.
So I request everyone to please switch on the video for a quick photograph, and then we will close. Radhika, if you can also switch on your video.
Sorry. It's been stopped by the organizer. I mean, you'll have to tell the IT team. Thank you.
Yeah. Hoimi or Andrila, whoever can click the photograph.
Yes, ma'am.
Yeah.
Supriya is taking the pictures.
So thank you, Radhika. Thank you, Professor.
Such a pleasure.
Professor Moradian sir, Indrapalji, Chaya madam, and all my colleagues in executive committee and JBIMS and all the members of BMA and JBIMS family for being with us for this interesting session. Thank you very much. See you on Wednesday at 4 o'clock in conversation with Professor Rajan Mehrotra and VP Raja.